and get it ratified.
Right.
And if you make it so specific that it becomes contentious for a specific group, you may
Right.
lose their support. You may not, so the vagueness of some of the wording creates the opportunity to spin
Right.
and get the support and in some instances tickle the ears of those that of your audience.
Right. I think that's exactly right. And so in a way, they were originalists and living constitutionalists, all of them in their own way. We have to have some meaning here. These words have to be precise, but they can't be too precise, or the meaning can't be too hard. Because number one, we got to get this approved, and number two, keep in mind, there are 55 delegates in Philadelphia. Even when they voted for it, they voted for it for different reasons and saw it in different ways. There's no one mind that says this is what the Constitution means. They all agree. No, it never would have been approved if they interpret every single phrase as this is what every word means. You'd never have gotten any document out of there in the summer of 1787, let alone be able to get to actually have a vote and get 9 of 13 states to approve it. Mark.
I just want to ask you a question. You're obviously more a court follower than I am. They do interpret. How much do they bring in Federalist Papers and notes and
Yes.
things like that, and that's considered a valid, reference?
Yes, absolutely. So Mark's question is, when the Supreme Court has a constitutional case, do they look at the Federalist Papers? And the answer is yes, absolutely. Here's the challenge that everybody faces with this when we look at 1787. What do they mean? Or 1789. The problem, of course, is that they disagreed at the time themselves. They were politically divided. As I said, the 55 delegates all have their different view of what all this means. We saw a really dramatic example of this with the D.C. v. Heller case in the U.S. Supreme Court in 2007, where that was an issue over what's the Second Amendment mean. In particular, in fact, let's look at the Second Amendment while we're here, just to have an example. So everybody, if you flip to page 323, so keeping in mind that this is not part of the 1787 Constitution, this is adopted in 1791. If you look at 323, it says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, with commas unhelpfully positioned in different locations in this. Right. Well, this Supreme Court case in 2007, the Supreme Court, by and large, had avoided the Second Amendment because they knew it's a complicated historical record. It's not exactly clear what was going on in 1791 here, and they generally have wanted to leave it to the states to figure out to the present day. But in 2007, the District of Columbia prior to 2007, the District of Columbia enacted a sweepingly restrictive law on the right of residents of the district to keep firearms, in particular pistols, in their homes. And that was challenged, and that case went all the way to the U.S. Supreme Court. And it was just about one word, ultimately, this case. It was about the word keep. The Supreme Court still, we're waiting for a case. There are a bunch of cases in the intermediate courts of appeal right now interpreting the word bear. The U.S. courts of appeal have divided sharply on this, on what that word means. And in D.C. v. Heller, they didn't get to it. They just stuck to keep. And what's so interesting about that case, what the court held was essentially that the Constitution protects your right to have a firearm in your house, subject to reasonable restrictions by the local government authority, but the local government authority, be it the state or the municipality, cannot implement restrictions that would have the effect of essentially denying you the right to have that firearm. And the D.C. law was so restrictive, it made it almost impossible to have a usable firearm in your house. A majority of the court held that that is unconstitutional. But what's so compelling about that case, it'd be worth looking up if you're interested in this, D.C. v. Heller, just to go to this question that Tim and Mark had raised regarding how do we interpret the Constitution. The majority and minority opinions are deeply informed and analyze the history of the 1770s and 1780s. And what they show is, in the majority opinion, they found it on the history, which is, like we talked about this morning. What set off the shooting in the Revolutionary War? What was the event? I mean, Battle of Lexington and Concord, but what were the British up to that leads to this violence? Exactly. They're going after an armory. there's going to be trouble. In 1775, any American colony, the central authority is coming to take firearms away from people in the middle of a big dispute, political dispute over the rights of the people. That's going to lead to bloodshed. So clearly, as the majority pointed out, this notion, 1791, when they write this, they clearly have a strong sense that firearms are connected to the individual freedom of the people. But what's also interesting, then the dissent pointed out, while that's true, it's also true that early on, very shortly into the constitutional era, in the aftermath of 1791, the central government, led by George Washington, were out going after the whiskey rebels, disarming people. In the 19th century, there were many, many restrictions. The Wild West, for example. It was very common throughout the Wild West, as federal marshals moved west to bring order to the towns, to ban firearms from towns. In fact, the shooting of the OK Corral is in part a consequence of the fact that the Earps, representing federal authority, had prohibited the cowboys from coming into town with sidearms. You had to turn over your firearms before you came into town. So the point simply is the Supreme Court's always looking at our history to try to figure out what does the Constitution mean. But of course, history provides lots of ammunition, sorry for the pun, for lots of different positions. But yes, the bottom line is what you all do, teaching the history and the civics portion of all this, is exactly what the debate over the Constitution always turns on, which is what does this document represent? What did they intend for it to represent? What does it mean in American life today? So you really, in a very profound way, each and every one of you is on the front lines of American constitutional law. Because ultimately, what the Constitution means is what the courts think it means, but that is absolutely shaped by what the people think it is. Because where do the judges come from? The judges aren't just dropped from 30,000 feet and parachuted directly into the federal courts and U.S. Supreme Court. They're coming through our school system just like everybody else, shaped by how people discuss the Constitution, think about the Constitution, think about our history, shaped by all of you, and then ultimately go to law school and end up on the federal bench. But keep that in mind, the students that you're teaching, you may well, you're teaching the future of the U.S. Constitution essentially, because the Constitution, what it means, will ultimately be determined in the future by future generations and how they interpret what this means and what methods we should use to reach conclusions about the meaning of the Constitution in American life today. Well, I just want to briefly look at the Declaration, just one key part of the Declaration, and then I want to get actually into the Constitution. So everybody, just note, because I think you all have the Declaration of Independence, what's really quite striking is in the second paragraph. So this is written by Thomas Jefferson. He's a young man. He was 33, a very well-regarded attorney and intellectual who's representing Virginia, one of the Virginia delegates to the Continental Congress. When the decision's made to actually declare independence, John Adams and Benjamin Franklin assigned the job to Jefferson because they knew he was such a good writer. And it also shows how important good writing is. They understood it, that anything lawyers do, they need to be able to clearly explain what it is, the point they're trying to make. Well, note in that second paragraph where it says, "We hold these truths to be self-evident." It's worth it. Just go ahead and highlight that first clause, that all men are created equal, that they are endowed by their Creator with certain, and go ahead and underline this key phrase, unalienable rights, that circle that word among these are life, liberty, and the pursuit of happiness. So what they just do there, because this is Thomas Jefferson writing it, but the Congress is going to approve. This is the final, this is actually the edited version. They cut out some parts of the Declaration that had been originally drafted by Jefferson. So this is his language, but it's the edited, approved version that they agree to. Note right away, they're stating that there are rights, what they would call natural rights, that exist everywhere, regardless of what the government says your rights are. So they are building into the Declaration of Independence the idea that the government's powers are not unlimited, that people have certain rights that transcend the time they live in, the place they live in. And then note, as we move on, they state, it shows that even in the Declaration of Independence, they're dealing with this Bill of Rights problem they haven't gotten to yet. But that is, they state that all men are created equal, that they are endowed by their Creator with certain unalienable rights. And then look at the clause that follows, comma, that among these, even here we see they don't want to list all the inalienable rights. Jefferson knows there's this risk, as Mark said before. You might forget one. You might leave something out, and a future government could use that against them to say you only get the rights that we've identified here. Jefferson states life, liberty, and the pursuit of happiness. You can kind of in parentheses put property. That's where they originally get that from John Locke. But it shows they are already aware that when you are declaring that you've got rights, you have to be careful of not being too precise and too confining in articulating them. Okay, now another thing note here. In the very bottom of that, it might be slightly different in the middle school textbook, but if you skip down, the same paragraph where it says, but when a long train of abuses and usurpations, comma, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, meaning when the government's despotic. It is their right, and by their, he's referring to the people. It's the people's right, and then goes on to say, it is their duty to throw off such government and to provide new guards for their future security. Now, we've heard all this so many times, it just, to us, yeah, it just makes perfect sense. But think about what Jefferson has done here and what the Congress is approving. They're writing into the Declaration of Independence an inherent right to revolution. Now, keep in mind who the ultimate political authority is here at the time he writes this. It's even beyond Parliament. It's the king. And going back to the Middle Ages, there's been this notion of the divine right of kings. You may have heard that. I'm sure many of you are familiar with that concept. The divine right of kings is what kings would use to justify the fact that, hey, I'm the king. I'm the king because God wants me to be the king. That was critical for rejecting the notion that the people have a right to revolt, because the idea of the divine rights of kings was that if you rebel against the king, you're rebelling against God. So what Jefferson's doing here is saying, no. There's no divine right of kings. The divine right of kings notion has things exactly backwards. As he goes on to say, the purpose of government is to promote the liberty of the people and to provide order so that we don't have chaos and disorder. But government's job is to promote the common good. If government stops doing that, we have the right to rebel, even if it's a king. And note, he says it's more than that you have the right to rebel. If you have a tyrannical government, it's your duty. This is so radical. This is to us, we're just so used to this language. But if you're sitting in Parliament, and a couple months later this document shows up, and you see what these Americans have said, you realize there is a very different political culture on the other side of the Atlantic Ocean. And the British were determined to defeat this insurrection, this rebellion, which posed a threat to the fundamental underpinnings of British government. Yes?
I also think Mike is unalienable. Like, you can't really go. Not like, can they not take it from you? You can't do it. Someone else.
Right. Yeah, Mark's point is this idea that they're inalienable rights. Exactly right, that the way Jefferson is formulating this, he's saying these are rights that are essential to being a free person. You cannot give them away. It's an interesting take. It's a more positive take in some ways. It's sort of along the lines of John Locke. Thomas Hobbes was the great rival to Locke in some ways, at least intellectually. Thomas Hobbes was somebody who had a very negative view of government in that he viewed that without government, we got chaos and anarchy. It's basically like the Road Warrior movie, if anyone's ever seen that, the old Mel Gibson movie. I guess there's a current version of it, just chaos. And that you need government to bring order, but then government inevitably takes away your rights and powers. What Jefferson's doing is he's more in the John Locke tradition that says we need government to prevent basically the strong from oppressing the weak, or the self-interested from putting their interests ahead of the common good. But at all times, we reserve core rights that you cannot give away to the government. Now, the Declaration of Independence in many ways was the much easier document to write. Because if you look at the rest of the document, note how, starting with the very next paragraph, Jefferson lays out everything that King George III and British Parliament's done wrong, which again, note how radical that is. They're calling out the king by name. They're saying, here's the king and he's a tyrant. He's actually saying that in here. Now again, keep in mind everybody, there's an army already there, the British Army. And Jefferson's saying that army has no legitimacy to be here. The king that they report to is a tyrant. There's a tremendous amount of risk associated with this. We all know that the revolution will succeed. They will achieve their independence. But Jefferson doesn't know that in July 4, 1776. And he knows if they lose, his name's on this document, as is everybody else's. And indeed, they all believed if they lost the war, everybody who signed this document would be executed. Indeed, they likely would have been. Now note, knowing the stakes, he lists everything that the king has done wrong in terms of, not in terms of mistakes of policy, but in terms of tyrannical acts that violate the natural rights of citizens, of Americans. And they include, noting here, at the very top, for example, of 307, if you have that, he says, no, the king's controlling the jurisdiction of our assembly, the jurisdiction of our courts. They're quartering troops, large bodies of armed troops among us. They're imposing, in many ways, one of the single most important lines, if you see it in the column on the left, in the middle on page 307, where Jefferson writes on the list of things that the king has done wrong and why we're rebelling. We're rebelling because he imposed taxes on us without our consent. They've deprived us of our right to jury trial. And then in the last paragraph, they declare their intention to rebel. So this is a list of things that have gone wrong. The challenge in the Constitution is, how do you figure out how you create a government that won't end up just replicating the tyranny of the British government, at least the tyranny from the perspective of the Americans? And for those of you at the high school textbook, we see their first effort, and that's the Articles of Confederation. And the big thing about some of you don't have it, so we won't spend much time on the Articles, just to note a couple things about the Articles of Confederation. The Articles of Confederation were agreed to after about 5 years. In the middle of the war against the British, the Articles of Confederation were debated in states across the country, but it took years until the states finally agreed to accept the Articles of Confederation. The states were essentially operating as independent states, except to the extent that they were supporting the Continental Army or coordinating in some activities against the British. But the Articles of Confederation, as a result, are an extremely weak document. How many justices are in the Supreme Court in the Articles of Confederation? 0. There is no court. There's no judiciary in the Articles of Confederation, because this goes to our question Tim raised before, because the power of the federal courts. Yes, Mark?
There's no real executive either.
There's no executive.
It's kind of, it's almost like a parliamentary thing where you've got a legislature, then grabbed a few people out of there to do executive things. But there's no executive.
Exactly right. There's no executive to speak of in the Articles of Confederation. All significant acts taken by the Confederation Congress require 9 of the 13 states to agree to it. The federal Congress lacks the ability to tax. So the bottom line is, in their first draft of a constitution, they end up with an exceedingly weak document. Well, what's wrong with that? Why do you need a stronger one? In the Declaration of Independence, they listed all the problems. Yes, Brian.
With the articles, the states just kept their individuality. And it was still, what's in it for me?
Right. So why is that a problem?
you're still elected 13 independently minded
Right.
government.
Exactly right. So Brian is the issue that the founders were concerned about, that we had 13 states that are just interested in their own interests and don't have a broader national interest. But why is that a problem? Mark.
My point was gonna be that when I talk to my students about the articles, I call it a club. And the states joined because they had a reason to join, whether it be, defense or foreign policy, whatever, but they didn't feel obligated enough to stay. And they could have left, if they wanted.
Well, they called it a league of friendship.
Yeah, which is what a confederation is.
They're right. Therefore, what happens when they cease being friends? There's no one there to settle the disputes, in which, all right, you know, they said they just had a very poor experience, terrible experience with the monarchy, a constitutional monarch. So they wanted to distribute power geographically in the weakest manner that they could. And the problem was it was too weak.
Absolutely, this is a key point. It's 2 weeks. Why is it 2 weeks? Tim?
I would make a comparison with the EU today. And we don't hear a lot of people arguing that that is an ineffectual organization. It serves the purposes of those independent and sovereign states that are a party to it, which perhaps if they would have just tinkered with the edges of the Articles of Confederation, that same kind of arrangement could have worked without such a drastic overhaul.
Right. Let's talk about that. What's the one, what's that?
It gives states a choice whether or not they want to contribute to it instead of.
Right, it's voluntary. You cannot compel them. And keep in mind the Revolutionary War experience. In fact, the people, key figures like Washington and Hamilton who were involved in writing the Constitution. During the Revolutionary War, one of the lessons the Continental Army had taken away from the fighting was the states will not be there for you when trouble comes. Indeed, the militias would run. In fact, part of Washington's mastery, or skill he developed to master how to use the militia on the battlefield was, the realization was the only troops who are going to stay and fight to go toe-to-toe against the British Army are the Continental troops who've developed an allegiance to the U.S. as opposed to just a state. But he didn't have enough men to win the war with the Continental Army alone. He needed the militias to help him. And one of the things he developed was an ability to work with the militia commanders to persuade them to stick around on the battlefield to fire at least 2 volleys into the British Army. And then they could run. And the militias ran in almost every major Revolutionary War battlefield. The militia, the state, the units focused on their states, they took off and skedaddled, is the term they used in the Civil War. And Washington's genius was to figure out, through hard experience of fighting the British Army, how to position the militia on the battlefield so that they'd be close enough to the British to actually kill and wound British soldiers, while at the same time having an escape route that would not be through the Continental Army's lines, because in the early battles, the state militias, when they turned and ran, would create chaos when the Continental Army is trying to line up shoulder to shoulder going into battle. If you've got hundreds, thousands of state militiamen running scared out of their minds by the rapidly descending on the British Army, that creates chaos in the Continental Army's lines. And so when you get to 1787, this group of people who write the Constitution are skeptical of some of the rhetoric that came out of the Revolutionary War about how noble the states are. They saw on the battlefield that the states did not defeat the British Army. It was a unified national organization where people's primary allegiance was to their nation, not to the state, that defeated the British. And then secondly, Patrick talked about this for a second, this issue that you can't resolve disputes. It was certainly true. There was no mechanism. If South Carolina and North Carolina aren't getting along, there was no mechanism to resolve it. But the problem went deeper than that. This is where it was a worse problem in the EU. Commerce is absolutely critical, then and now. You need economic growth. You need to be able to trade, if you're in Charleston, to sell goods to people in Wilmington or Newport or New York, and vice versa. Oh, currencies, certainly you need that, but they'd work around for it. But their problem is this. Anyone who's a lawyer knows contracts get violated. Breaches happen. People go into business, things go poorly. Well, you need a court to resolve that. We already had courts in every state. They had extensive court systems. The problem was, after the British were kicked out through the 1780s, time and time again, state judges and state juries ruled in favor of the in-state litigants. So in other words, if you're in South Carolina court, you're a North Carolinian, you sold goods to somebody, they didn't pay you. You go to South Carolina to sue them. Even when the facts and evidence are all on your side, the South Carolina court would rule for the South Carolinian. Same problem happened in every single state, to the point where business was being profoundly undermined by how obsessed with states' authority each of the states were. And of course, with elected judges, they don't want to do anything that would be politically unpopular at home. That had a huge impact on the founders, because the founders in general, what's the big difference between the Federalists and Anti-Federalists? When we look at the politics of what was motivating people, certainly ideas are important. But historians know there's always a lot more going on than political philosophy. When they have mapped out how the Constitution was ratified, they have found that the single biggest predictor of whether you supported ratifying the Constitution or opposed it was not how much money you had. That was not. Charles Beard 100 years ago argued that, but historians subsequently found it was more complicated than that. The single biggest predictor of whether you supported the Constitution and a stronger central government or you were one of the Anti-Federalists was your proximity to water. That if you lived on or near a navigable waterway or on the coast, you were very, very likely to support the Constitution, because you're involved in trade and commerce in a broader world than where you live. The more remote people were, if you lived in the mountains and were just in a small little either subsistence agriculture or just a little bit more than subsistence agriculture, you're much more likely to be skeptical of cities, of trade, of commerce, and of any kind of centralized power. That's the fun, is the geographical element that informed the debate over the Constitution. Now, I want to talk about the substance of what's in the Constitution itself. In the 1780s, by the time they get to 1787, the Americans face the reality that, again, this is different than the EU, though maybe it's with Vladimir Putin, maybe it's not. But the reality was, we have no national military. We have the states, which have always been focused just on their own parochial selfish interests. Continental Army's long gone, and we live in a dangerous neighborhood. You have the French, who've been defeated by the British back in the 1750s and 60s, but they're still around. They had supported the American Revolution, provided critical aid to us, but they didn't do it out of the goodness of their hearts. And you have the Spanish, who are still present, and you have something else. The British, who are still a superpower. And the British had provided naval protection to the American colonies for 150 years. That's gone, now that the British Navy is no longer America's Navy. So there was very real fear that not only do we have all these economic problems, but we've got the problem that there's nobody protecting this country in a very tough neighborhood. And the states tend, if an emergency happens, the revolution showed they don't band together very quickly or very well if you don't have some kind of institution already in place. And then third, the states were in massive debt. They had all paid for the Revolutionary War on credit. But of course, that meant once you get to the 1780s, they're in debt up to their eyeballs. That would be crucial in why this Constitution gets ratified, as we'll talk about in a second. But for this combination of reasons, you have 55 people get together in Philadelphia in 1787 to draft a Constitution. Let's look and see at the final version, what we actually end up with, everybody. So if we turn to page 315 in your textbook, and what page is it on?
280.
And 280 with the middle school textbook. It is the same. The Constitution is the same whether it's the middle school textbook or the high school textbook. Exactly. All right, no. So interesting. If you look at the Declaration of Independence, it refers to the states. What the states are doing, what the delegates are doing. Articles of Confederation said the same thing, conceptualizing the fundamental political unit as the state. But again, the founders, 1787, a little more skeptical of the states. And they also know the state legislatures are pre-existing powers, power centers. They have every incentive to say no to central authority. So look at the first three words of the U.S. Constitution. What are the found? James Madison's there scribbling away. Gouverneur Morris is also a key writer here. Look at it. It's a preamble. We the key word. People. Go ahead and even circle that. That is there for a reason. That is not just a rhetorical flourish. What the founders do is they say, we are here in Philadelphia writing a constitution for the entire country, for the people themselves. We're going right to the people. We're skipping the states, going right to the people.
States out of it.
Right, exactly, Mark. The whole idea is to get around the state governments, because they're their own power centers. They have their own lobbying interests. Their own. I mean, anybody who's in a state legislature now has an institutional affiliation with that institution, rather than the country as a whole. So they're saying we're going right to the people, and then the people of what? Of the United States. They don't say we, the people of the separate states, the 13 separate states aligned here along the coastline in North America. No. They say we, the people of the United States, and then go on to say what we're trying to do here. First thing, form a more perfect union. So before they get even into the text of the Constitution, they're telling us we're about unity, which inherently means we're about national authority. And they're linking national authority with the people. Now, this Constitution's filled with deference to the power of state legislatures. It is. But in the first sentence, they tell you big picture what we're about. We're about a unified national government and the people. That's the first goal articulated in the Constitution itself. Now, as you all teach this so you know, what is the first institution they address in the Constitution? The legislative branch. That's not by accident. They don't, Article 1 of the Constitution, you can put there in your notes, Article 1 is about the legislature. First institution, because it is the leading institution. What's the next institution they deal with?
Is that because it was in the articles? Is that why they put that first?
No, but let's see, Josh's question is, so why they put it first? They put it first because ultimate authority when it comes to actually enacting laws comes from what branch of government? The legislature. So the Constitution's telling us what the big picture framework is. Hey, Congress, President, you can't go beyond the limits we're creating here in Article 3. But then, when you're operating within those limits, where's the law coming from? Because it's not coming from the President. It's coming from the Congress. Presidents are not capable of passing laws. They sign them or they veto them. But the law comes from the legislature. So this is a recognition of this long-standing British tradition, at least since the Civil War, English Civil War, and really going as far back as the Magna Carta, of the Parliament being the seat of action in terms of legislation, not the executive. Now let's just note the first chamber they address. So we have Article 1. Section 1 says, look, all legislative powers are going to be in a two-chambered legislature. Pennsylvania was the one state legislature that was unicameral. Everybody else had gone for two chambers. Note, what's the first one they talk about? The House of Representatives. Right. Now that's revealing. Who's the House represent? As they say here, we think today.
General population.
Exactly. The people. Indeed, the way the founders are looking at this, the House of Representatives is exactly what it says it is. It's representative of the people of the United States. And indeed, they emphasize that not only is this a body to be elected by the people, but it is a body to be responsive to the people. It's something we take for granted. How long? The U.S. Constitution, the founders, their first business when they get into the nitty-gritty of this, how long are House terms? 2 years. This is a short term. The idea being the people get to exercise their own veto on whatever the House of Representatives is doing every 2 years. That length of term itself is a limit on power. But the fact that they lead with the House of Representatives, first government body to talk about, shows how important it is. And again, we're going back to those first few words. We the people of the United States is what this Constitution is a product of, the People Act. Now, I'm sure you talk about this with your classes. The single most important compromise that happens at Philadelphia when the delegates get together, they're secretly drafting this Constitution. The compromise that made this thing possible is the Great Compromise, where they figured out how are we going to do representation? Because the 13 states had dramatic variations in population. You've got Pennsylvania, New York, and Virginia, 3 big population states. In there was Rhode Island. Indeed, Rhode Island didn't show up to the Constitutional Convention. They were that worried about it. But they knew going in, if this thing doesn't work, this Constitutional Convention, is going to be because we cannot figure out how to have a balance between giving states equal representation in some areas, but reflecting population disparity in others. Because if they just came in like the Articles of Confederation and said every state gets 1 vote, what does that do? Again, who is this Constitution about? Who are the delegates acting on behalf of, as they tell us the first line? The people of the United States. The article is all about protecting the states individually. The Constitution comes and says we're here for we the people of the United States. Well, if every state gets 1 vote, that means a vote you cast in an election in Rhode Island means a whole lot more than a vote you cast in an election in New York. Because your election, a vote you cast in New York is just 1 small fraction of a big electorate. Whereas in a small state like Rhode Island, that vote you cast is extremely influential. And that would mean a very small population center could exercise disproportionately large power over how American policy is actually crafted and enacted. Consequently, they knew if this is really going to be a democracy, we've got to have proportional representation in here somewhere. No offense to us as Iowans, but the Californias and New Yorks and Texases cannot be equal in the national legislature as smaller states if we're actually going to claim we're a democracy. Because we're not then. Because in a way, you're a tyranny of the small states over the big. Because you've watered down the influence of people in the big states. And so, of course, the way they do it is they create a Senate that's based on the states. Every state has the same amount of votes. 2 senators per state. And a House of Representatives that's based on proportional representation. So in other words, Virginia's got more members of Congress than Rhode Island does. And New York's got more representatives than Connecticut. Okay? Now, noting here in the Senate, one key thing to know in Section 3. So far, they're really emphasizing this is about the people as a whole, as Americans, and this is about unity in this national government we're going to form. But with the Senate, it's so interesting. Look at how senators are elected under Article 1. They're not elected through a general vote of the people in the state. Who elects senators?
Legislature.
Exactly. The legislature does it. You see it right there as we look at in Section 3, Clause 1. So that very first sentence tells us the Senate of the United States shall be composed of 2 senators from each state. So far, so good, just like today. But then it says, chosen by the legislature thereof. Now, that's in brackets for a reason. This Constitution was amended 100 years ago to provide for direct election of U.S. senators. But the fact that in 1787 they wrote it so that the state legislatures choose the senators shows that the founders are recognizing for the first time in the Constitution here that the states themselves, as legislative bodies, are an important constituency whose voice needs to be heard. So the people directly, national unity, but the state legislatures have a role here through the senators themselves. Now, another thing to note, which is interesting here, what's the constitutional age requirement to serve in the U.S. House of Representatives? 25. What's the age requirement for the U.S. Senate? 30. So it shows, although they have equal weight within the Congress, the founders from the beginning believed the Senate required a little more age and experience than the House of Representatives, which is an interesting insight. Why do you think they did that?
Balance.
Balance, absolutely.
They want the House to be, the House is going to be impulsive because of the short term of the
Mhm.
So the Senate had to balance that impulsivity out by not being impulsive.
Right. Right, I think that's right, Mark. This idea that the House of Representatives serve for 2-year terms, they're going to be more responsive to the public mood, as Mark says, at any given time, whereas the Senate 6-year terms, we want the senators to be a little cooler, a little calmer, a little more deliberative. Even though we're giving them roughly equal powers, tax bills have to originate in the House, and the Senate has unique influence in cabinet selection, Supreme Court appointments, and treaties. So there's some differences in the precise powers awarded to the two chambers. But they are roughly equal institutions. You need approval by both if you're going to pass legislation. But the founders are conceptualizing different kinds of people will be in the two chambers. Now, everybody, let's flip to here, just to note one thing, which is really kind of interesting, is if you flip to the bottom of 316, section 14, or section 4, the first clause there, we note that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state. See by who? By the legislature. We just had a Supreme Court case interpreting this, a big one involving the Arizona redistricting battle. This is the clause that has given us the gerrymandering fights, because this gives the states the authority to do, until lately, pretty much anything they want to do. You want ferociously partisan redistricting, you can do it. But if you know, it's very interesting. It then has here, after the thereof, see where it says, but the Congress may at any time by law make or alter such regulations, except to places choosing senators. The reason they're so worried about the places business is they were concerned about some practices during the colonial period where the British or power centers and local communities would call an election, like a snap election, not have a lot of advance warning for it, and choose it in a location that's hard for voters to get to. There are lots of ways you can have a democratic election when there's nothing democratic about it. So it shows there's a concern that seems alien to us because we're so used to polling places being generally close to the people. The founders are putting this early on because they knew that we're dealing in a real world where politicians are going to do, they're not going to change their stripes. Politicians are still going to act to maximize their power. Therefore, we need to keep them honest here to ensure there are certain limits placed on how we actually decide how to choose people for office, how we decide district lines. But then also note here, the Congress has a corresponding power when it comes to federal elections to regulate if the states engage in redistricting practices, for example, that are considered undemocratic. That is why, under the current law of the land, you cannot write a congressional district line that leads to a significant population imbalance. So, for example, Iowa's got 4 congressional seats. Iowa's one of the rare states that has nonpartisan redistricting. We really have the model. The best way to do redistricting is the way Iowa does it. Lots of scholars have looked at this, political scientists, law professors, and if you want a fair way to do redistricting, Iowa's the place to go. The LSA does it, and then the legislature approves it, but Iowa's consistently been held as the model for redistricting that is fair and neutral. Now, most states do gerrymandering, where it's very partisan. The restriction that's essentially built into this through the Supreme Court interpreting the federal power here and what the Constitution mandates is, under Supreme Court jurisprudence, the state legislatures may not draw district lines that would result in a small district having the same weight as a large district. In other words, with 3 million people in Iowa, we have 4 congressional districts. You could not draw our congressional district lines to say, okay, Mason City You elect one member of Congress, Sioux City, you elect one, and Cedar Rapids, you elect one, and the whole rest of the state, 2 million people in the rest of the state, will elect the fourth. That had happened, not in Iowa, but in other states. There had been outrageous imbalances. This happened first at the state level. The states had a long history. Tennessee was the most outrageous example of this, where essentially they gave rural counties, a rural county which is a few thousand people in it, would elect the same numbers of members of the Tennessee state legislature as the whole city of Memphis. And this was such an outrageous imbalance that and the states weren't fixing it because, again, the legislature, the people who were there, had an incentive in keeping the status quo in place. So the Supreme Court came in 50 years ago and struck that down, saying that's not small d democracy, that's not consistent with what the Constitution requires. And then they went ahead and said the same thing for federal elections. But you can see that we think of election chicanery as being some kind of new thing. No, the founders knew from the first time the first ballot was ever cast, there's a risk of corruption and a risk of the system being rigged. So they're trying to address that early on in the Constitution. Now,
So wasn't the population consent early on because it was 1 to 30,000? So he realized the number's gone up, what is it, 750,000 now?
right.
But shouldn't that's the standard, why would those districts be allowed to have such ridiculously imbalanced populations?
Right. This is
Because it was already set.
right. Mark, this is what exactly. Did anyone know how many? It's actually in the Constitution. How many representatives we started out with in the House? 65. 55 delegates to the convention. 65 there. And just exactly as Mark says, the Constitution creates this floor of 30,000. They were originally going to have a floor of 40,000. And Washington, among others, said that's too big. We need a smaller congressional districts that are more responsive to the people. Well, for the most part, every 10 years, the Constitution requires a census. When you do the census in 2020, or you did in 2010, that's required by the Constitution. Every 10 years, because we need it for tax purposes and a population apportionment for the House of Reps. Every 10 years, our House of Representatives grew from 1790, from 65 to 1910. 1910, they hit 435 members of the House of Representatives. Well, you'll note, so 106 years ago, that's the same number we have today because Congress stopped increasing the size of the House of Representatives. Now, historians have looked at this. There are a whole bunch of reasons why they stopped doing it. They claimed that, it's getting too expensive to have too many members of Congress. Size of the building, even though the British Parliament's smaller and has 600 members in the House of Commons, even though they have a smaller chamber than we have, they're able to, we think of the presidential joint sessions of Congress, they've got a whole lot more than 435 people in there they're comfortably able to seat. But that's an example of how scholars have pointed out, arguably, we violate the Constitution every 10 years when we don't increase the size of the House of Representatives to shrink the size of congressional districts to be consistent with what the founders thought, which was the House of Representatives would grow so that you have smaller districts that are more responsive to the people. The bigger you get in population, if you keep only 435 people in the House of Representatives, they're inevitably going to end up with House districts that are going to far exceed 1 million people in population. That's that's bigger than any state by far in 1790. Right. Now, this is a standing issue. The question is, how do you challenge that? This is a standing issue, which we don't necessarily get into details of it other than this sense, that there are some constitutional issues that a private citizen can't raise. Essentially, we call this taxpayer standing. We as citizens, in general, don't have a right just to sue when the government does something unconstitutional. We have to show personal injury. So if the government's unconstitutional action injures you personally, you have standing, which means a right to sue in court. But if it's just a generalized injury, generally you can't get in. This issue's come out with Ted Cruz. He was a Republican candidate for president. He's a U.S. Senator from Texas. He was born in Calgary, Alberta in 1970. In 1974, his family moved to the United States, moved back to the United States. His father was a Cuban citizen. His mother was an American citizen. The Constitution, in fact, let's even flip over so we can see. This is a good segue to go to Article 2. So flip over to, no, it's actually in the Constitution. We flip over to page 318 in Article 2, you'll see it says, Article 2, Executive Branch. So it lays out, the Constitution lays out the qualifications to be President of the United States and the powers. We'll switch to Clause 5. This is right in the Constitution. Article 2, Clause 5 of the U.S. Constitution states, no person except a natural-born citizen shall be eligible to the office of President. That other clause refers to the idea as, if you've been in the States long enough in 1788, when this thing gets ratified, you can run for President. So Alexander Hamilton could have served as President if he hadn't been shot and killed by the Vice President. But, Aaron Burr. But, okay, so that's it. What does natural-born citizen mean? Well, we as citizens generally would not have standing to sue here. There have been a lot of law review articles written about this. Came up when John McCain ran in 2008. He was born in the Panama Canal Zone, which was a U.S. military base. It was a sovereign soil of Panama. And what was pointed out is, really, because we have such a complex legal structure, the only way that could be challenged would be through the states themselves, because the states decide that clause we looked at before, everybody, about the states being in charge, essentially running the elections. If you had a state attorney general who said, I'm not putting this person on the ballot, then there's an issue that could get litigated, but that would be between the campaigns and the state AGs. It shows this is a complicated document legally for litigating constitutional issues. Now, while we're talking about that, let's flip over to Article 3, everybody, to look at who would resolve this. If we actually could get a constitution, and indeed, the Supreme Court's, just so to make this clear, everybody, though there are standing challenges for an ordinary citizen if you're not directly personally injured by something in a very particular way, if you are injured, you absolutely are going to be able to get into federal court and have your claims heard. I do want to emphasize that. The Supreme Court, most of the cases that certainly get reported in the press are all these constitutional cases where the court's having to interpret what the Constitution means. Well, Article 3 is very revealing of how the founders didn't want to get pinned down too much in details about what all this necessarily means. Article 3, see the branches created there? The judiciary. So Article 1, they said the legislature. Article 2, they said the executive branch, meaning the president, single president, natural-born citizen, over the age of 35. And third, the judiciary. Now, they knew that this article was political dynamite. On the one hand, they knew we've got to have this, because the state court systems are not protecting the rights of Americans who aren't from that state. We've got to have a federal judiciary to have a neutral place to go to arbitrate the normal, everyday legal issues that emerge in a modern society like modern America in 1787. But they knew they had to be careful with it, because they knew there'd be a lot of pushback. So let's look at that first sentence. This has got so much in it. Article 3, Section 1. Creating the judiciary. It says the judicial power of the United States. You can go ahead and put, like in the margins or something there, if your students ask you about this, what does that mean? Judicial power of the United States, that means the federal judiciary. The key word is the United States, because they knew if this said the judicial power of America, the Constitution would never have been approved. If the federal judiciary was replacing the state courts, not a single state would have approved this. So they needed to alert everybody, hey, relax, relax. All we're talking about right now is federal judicial power over federal legal issues, or issues that in one way or another affect the jurisdiction that's about to be granted in Article 3. Okay, so far so good. So our federal courts shall be vested, and the key word there is shall. In law and statutes and in the Constitution, the two key verbs I always look for are shall or may. May is discretionary. You don't have to do it. Shall means must. Okay? So the framers are telling us the judicial power of the United States must be vested in one Supreme Court. So what this tells us is Congress cannot shut down the U.S. Supreme Court. The Constitution requires its existence. But you'll note, it then goes on to say, this is all law students, like first year of law school, you're always shocked to realize what's actually in the Constitution. Look at the first sentence after that, comma, so after the Supreme Court, comma, and in such inferior courts. What inferior court means is lower federal courts. So that means federal trial courts, the district courts. There's one just within walking distance of us right now, the U.S. District Court, the Southern District, Iowa. It's the federal trial. You sue someone in federal court, you don't go to the U.S. Supreme Court, you go to the federal trial court first. So an inferior court here means, inferior federal court means a federal trial court and federal courts of appeals, the intermediate. We have a 3-level judicial system in the United States, both in the states and in the federal government. You have your trial courts, where the cases are heard. Then you have, if you're going to appeal, you have an intermediate court of appeals, we call it. We are all covered right now by the 8th Circuit. That's a federal circuit court down in St. Louis. And then at the top of the ladder is the U.S. Supreme Court. So with that in mind, U.S. Supreme Court, got to have it, Article 3 tells us. But now let's look at our intermediate courts of appeal and our federal trial courts. The Constitution tells us, and in such inferior courts as the Congress, and now look at that word, may, from time to time, ordain and establish. What's so mind-blowing about that for law students, and I think for most people, when you've never encountered Article 3, the actual text of it is, that tells us, hey, Congress doesn't have to create a lower federal court system if it doesn't want to. And even more radically, if you look at just the plain meaning of the words, and indeed what they meant at the time, even if Congress creates a federal trial court system, if they want to, they can implicitly in here get rid of it, because it's from time to time ordained and established. Why'd they do this? So crazy when you first look at it, is because they knew that Congress was highly likely, because most of these guys would be serving in Congress, to immediately create the federal courts, which they do through the Federal Judiciary Act of 1789. But they also knew it's got to be done in an unthreatening way. If we tell the states, hey, we're going to have lower federal district courts, that would reduce the chance of this document getting approved. And we had to assure the states, hey, if the federal judiciary gets too powerful, Congress can shut them down. That's what that second clause says. Now, if Congress ever did exercise it, like the plain meaning of this, and say we want to get rid of every federal trial court in the United States, except the U.S. Supreme Court, there would be a riot. 9 people in black robes who are in a building across the street from the Capitol right now. They're called the U.S. Supreme Court Justices. They would get pitchforks, and they would run into the Capitol building, breaking windows and raising heck, because 9 people cannot handle the federal judicial business of the United States. They need federal trial court judges. They need federal appellate court judges all over the U.S. to handle 99.9% of all federal litigation. But this shows, again, the founders, they're intentionally a little vague here, because they know we have to have a federal district court system, but we don't want to come out and say it's mandatory. Only the U.S. Supreme Court is mandatory. Now, you also know how many justices serve on the Supreme Court according to the Constitution? Doesn't say. So, right, technically, they've been down to 5, we've gone up to 10. There's been fluctuation. Congress, there's a federal statute that determines the number of justices on the Supreme Court. It's currently 9. But the Constitution doesn't require it. This is why FDR's famous court packing plan, where he tried to essentially put 18 people on the Supreme Court, that was not a constitutional battle. The Constitution doesn't say a thing about that. That was a political battle. No, he lost. But that shows Constitution's intentionally vague about that issue. They don't require anything. Now, we'll skip down everybody to Section 2. Keep an eye on my time. I don't want to keep you here too long. Skip down to Section 2. That paragraph that starts with the judicial power shall extend to all cases, that lays out federal subject matter jurisdiction. Again, this is a potentially explosive paragraph in the Constitution. Most of these people there in Philadelphia, 1787, they're lawyers and farmers. Farmers used to litigation. And people and merchants, people who are knowledgeable, understood the importance of our court system. Although that paragraph lays out the subject matter jurisdiction, what you don't realize is this paragraph significantly restricts federal court subject matter jurisdiction. So let's look at that first sentence. It says, the judicial power, again, everybody, that just means the federal courts. It does not mean the state courts. It says the federal court shall extend to all cases arising under this Constitution. Does that make sense? That's how you get into federal court. If you've got a constitutional claim, government comes, takes your home without paying just compensation, you've got a federal constitutional claim, you can get into court on that. Second, the laws of the United States. That means statutes. And that's the heart of federal judicial jurisdiction. So you want to get in federal court, you got a constitutional violation or a statutory violation. If you note the rest, they build in here, just skip down a few parts to where it says that the federal courts also have jurisdiction over lawsuits involving citizens of different states. That is crucial. There's a huge percentage of cases in federal court. That's called diversity jurisdiction. What that means is if you're an Iowan and you get into a legal dispute with, let's say, Minnesota. You know what the Minnesotans are like. I'm from Minnesota, let the record reflect. Iowa now. But let's say Iowa citizen, Minnesota citizen in a dispute. This tells us, hey, litigants, you can have your case heard in federal court, even if it's a state law dispute. This was the driving force behind creating federal judiciary in the first place. They sneak it in there, and it is the basis to the present day of how a state law claim, a dispute over like the Iowa state law that regulates, let's say, commercial trucks. That case normally, if it's between two Iowans, if you've got a dispute over some Iowa state law that governs trucking, the federal courts cannot hear it. The Constitution prohibits them from hearing it because the federal courts are courts of limited jurisdiction because there's no way the states would have ratified the U.S. Constitution if federal courts could hear all legal cases in the United States. That's why the vast majority of lawsuits in the United States are heard in the state courts because the Constitution doesn't permit the federal courts to hear ordinary state law disputes between people in the same state. Only if you're in a state law dispute with somebody from a different state do the doors of the federal courthouse swing open to have that case heard because we want a fair forum for the litigants. So even if it's the idea being if you're in an Illinois federal court and you're an Iowan, the assumption is a federal judge is going to give you a fairer proceeding because that federal judge has a lifetime appointment because Article 3 tells us the rest of that paragraph that federal judges serve for life. The only way to get a federal judge off the court is impeachment. Only 10 federal judges have been impeached in history. But the critical point then is, on matters of state law, this always kind of blows people's minds, because the Constitution laying out restricted subject matter jurisdiction, if you've got an issue of Iowa law, the final word on that is whatever the Iowa Supreme Court says. The U.S. Supreme Court does not have jurisdiction over matters purely of state law to the extent that it would overrule whatever the state Supreme Court says. Federal judges are bound by, for example, in Iowa cases, and it's just an issue of interpreting Iowa state law. Whatever the Iowa Supreme Court says is binding on federal judges. So, for example, these diversity cases I told you about, so Illinois citizen in a lawsuit with an Iowa citizen. So two different states, that's how you can get in a federal court. The whole dispute's over some Iowa law. You get to have that case heard in federal court because the Constitution provides for diversity jurisdiction, citizens of different states. But the U.S. Supreme Court has repeatedly said the federal courts must follow whatever the state Supreme Court says the law means, the state law means. Okay, you see that? Just another example of the restrictions on the power. So we have a federal judiciary, the federal judges, and here's the key point, everybody. The U.S. Supreme Court's the final word on what this means, the U.S. Constitution, and what federal statutes mean. Okay, so the U.S. Supreme Court and the federal judges, they don't care what the Iowa Supreme Court says about federal law. They ignore that. They're going to interpret federal law for themselves, federal judges in the U.S. Supreme Court. But if it matters of state law, federal judges have to follow the state Supreme Court. So it shows to the year 2016, we still are very careful, the judiciary, about honoring the restrictions that were built into Article 3 back in 1787. Josh and then Patrick.
Okay, so Colorado with the marijuana issue, has that gone to the Colorado State Supreme Court? Why can't the federal government regulate that? Why wouldn't they regulate that, or do they choose not to?
Right, so this is, Josh's question is about marijuana. So Colorado has legalized, to a certain extent, marijuana consumption and sales. The federal government hasn't. So this is a classic example of the framers' dilemma that we're dealing with every day here. It's still a federal felony to sell marijuana in a certain amount in Colorado. So the state officials say, hey, it's legal under state law, but the federal government bans it. And so to say, well, what's the federal government doing getting involved there? Here's why. Everybody, let's flip to maybe the most controversial. There's so many controversial parts here. We could spend your whole course here just talking about the controversial parts of the Constitution. But let's flip to 1. This is the bottom of 317, Section 8. We're back in Article 1, everybody. So we're Article 1, Section 8.
284.
So 284 for the middle school version and 317 for the high school version. This is Article 1, so back to powers of Congress, Section 8. And this clause that we're talking about is one you've heard of. It's called the Commerce Clause. So everybody see it in Clause 3. This, you see the very top under Section 8 says, the Congress shall have power. So this is the Constitution saying the federal Congress is going to have power over, Section 3. The Congress shall have the power to regulate commerce with foreign nations. So Iowa can't do its own trade negotiations with Canada. They can do, I mean, the governor, they're always going overseas to promote Iowa agriculture. Sure, you can do that. But Iowa can't enter into a commercial contract with Canada that violates federal law. The Congress reigns supreme there, as long as Congress chooses to chooses to legislate here. So that's the first example. So, and Congress wants to impose tariffs. So Donald Trump's a big fan of tariffs. This says Congress can do that. Comma, and among the several states. That's the Commerce Clause issue that gets litigated all the time. That says, hey, when we've got commerce, this is the way the Supreme Court interprets it, when we have commerce that crosses state lines, Congress may come in and regulate it. This is probably the part of the Constitution that, realistically speaking, is interpreted today in ways that go so far beyond probably what they had in mind in 1787. But they wrote it in a vague way because they wanted that power for Congress. But they also knew if they came on a spell, today it's how the federal government regulates so much. I mean, so much of the government's regulatory powers are just in those few words where it says, hey, Congress has the power to regulate commerce among the states. Well, that leads to a situation like Colorado. Congress has held marijuana as an interstate issue, trafficking of marijuana. The Congress has entered into that area, asserting the Constitution gives Congress power to ban narcotics. Marijuana is one they banned. The state of Colorado said, hey, we're good with it now. What's happened is, operationally, there's absolutely no doubt if the FBI started arresting all the marijuana farmers and Justice Department prosecuted them to the fullest extent of law, even though Colorado law applies it, there's no doubt 9 justices in the Supreme Court would uphold what the FBI was doing. Because and this goes to policing power as well. So it shows what's operationally happening in Colorado is the federal government, for the most part, has just chosen not to enforce federal law in Colorado. Now, this is an example of it's kind of a loophole in the system, because if you're in Nebraska, you can bet when the Nebraska State Patrol pull people over on I-80 and they got lots of marijuana there, if state prosecutors choose not to prosecute it, you can bet the U.S. Justice Department will be bringing, you're going to be appearing before a federal judge in Omaha, but not in Denver. And so this has raised concern that we now, at least in one state, and to a certain extent, state of Washington, federal law is not being applied equally in every state. There's a little bit of concern about what does that mean when I can be prosecuted under federal law in state A, but effectively I'm free to do whatever I want in state B under the same law. Yes, Brian.
So I guess that almost answers my question, but is that going to change since Nebraska and Oklahoma are planning on suing Colorado because of the increase in drug traffic across the borders?
Exactly. This is a perfect follow-up, as Brian points out. So we have these neighboring states that are saying, whoa, Colorado, you're costing us tons of money in increased law enforcement costs because you're now a magnet for all, and it's not just marijuana. I think Nebraska, neighboring states, it's more than marijuana that's flowing into Colorado right now on the interstate highway system through their states, increasing drug consumption in their states. And they're saying this is a violation of our rights by Colorado. They're undermining us when federal law, which supposedly we've all agreed to, says these drugs are illegal, and we're all supposed to be in the same boat here. This is why you got a federal judiciary.
But doesn't this
Tim-
also
Tim and then
open
Mark.
up